Also, if the, as we said, if the tenant raises any defense other than payment, they have to put the money into the registry of the court. But they have a time limit on that as well. They have to do it within 5 days of being served with the eviction. They don't count the Saturdays, Sundays, legal holidays in that 5 day period. That's a consistent theme at evictions, not to count weekends and holidays.
Right.
But if the tenant does not do it within the 5 countable days, then you're entitled to get a default against the tenant and an immediate judgment of eviction without any further notice or hearing, because there's nothing the tenant can say at that point. They haven't raised any defenses. They haven't given notice to the landlord. They haven't paid money into the registry of the court. There's no defense. So it's a quick and easy way for the landlord to get the tenant out.
Exactly.
And usually that's what happens in most evictions. The tenant doesn't put the money into the court because they simply don't have it.
Now, one thing to remember about this, if the tenant is on assisted rent payments, such as subsidized housing, Section 8, they are only required to place the amount of rent that they're required to pay into the court registry. The amount of the subsidy, they're not required to pay into the registry.
Once you complete your eviction properly and you get a judgment of eviction, the next step is, how do you get the tenant out? Your judgment should have language that directs the clerk to issue a writ of possession. That is a document that's a court order from the judge, signed off by the clerk, and delivered to the sheriff, and the sheriff takes that writ, goes to the property, serves it, posts it on the property, and says, tenant, you've got 24 hours to remove your belongings and get out of the premises, and if you don't, then the sheriff will physically remove them from the property. The writ is also an important document that needs to have specific information on it. In addition to the name of the parties, the address of the property, the name of the tenant, the writ also has to have the contact information for the landlord or the landlord's agent, their name, their address, and phone number. Why is that important? So the sheriff, when he is ready to serve the writ, is going to call the agent and say, hey, I'm going to be there Thursday at 10 o'clock. You can coordinate with the sheriff to meet him at the property, to supervise the eviction, and to be placed in possession. You have to be at the property to receive possession once the tenant is removed. Additionally, you want to be able to notify your locksmith to be on call at the property to change the locks, to physically carry out the order and put the landlord back into possession of the unit.
Exactly. Now, fees and costs. In Florida, in an eviction, the prevailing party is entitled to recover their fees and costs. Why is this important? Obviously, whether you ever see the money or not, you don't want to be responsible for the tenant's fees and costs. So you want to make sure that you followed all of the steps, done everything properly, that your notice was properly served, that you've waited the requisite time so that the tenant doesn't end up being the prevailing party, and not only have you lost the eviction case, but now you're responsible for paying, if he has an attorney, his fees and costs as well.
It's a double-edged sword that, if you've done your eviction correctly, you'll recover the fees and costs for the attorney to file. If there's any problem that comes up, then you're going to be on the hook for the other sides. But because it's in the statute, it doesn't matter if it's a provision in the lease or not. It's automatically there. So, again, accuracy with the pre-lease documents is important, or the pre-eviction documents is important, so that you preserve your right to recover the fees and costs of the eviction.
Now, once you've gotten the tenant out, you may have to deal with property that is remaining. We recommend putting in the statutory language that provides that the landlord will not be liable for any property that remains in the property after surrender, abandonment of the property. Without that, you could create a situation where property is left, The landlord then becomes responsible for the property, is responsible for storing it, and even though the tenant may be responsible for paying storage fees, uh, if there's an allegation of theft or misuse of the property, if there's property missing, that's all going to go to complicate the eviction process. It's going to result in additional steps that the landlord is going to have to take. And if you put the disclaimer, the statutory disclaimer language in your original lease agreement, you won't have to deal with those issues. It's also important to remember that at the time that the landlord takes possession of the unit back, that all of the property be removed and brought out to the curb if the tenant isn't taking it with him, because any property left inside will create that additional relationship and the potential for liability on the part of the landlord.
Once it's put on the street, it's abandoned property, and you have no responsibility for that. And if you've done that while the sheriff is there and supervising, in addition to your locksmith coming to the property, you want to have people that are there to be able to move things. And again, document, take photographs of what was there. Once it's on the street, take a photograph of the pile, take a photograph of the vacant apartment so that you are covered, because nothing might happen at the time, but later on, the tenant might try to come back and make an allegation. But if you've got the proof, you're going to be covered. You'll be fine.
It's amazing how many people have possession of the Hope Diamond and have left it in an apartment after they've been evicted. You don't want to have to defend against that.
The other issue after termination of the lease is the security deposits. Now, as you are most likely aware, there are provisions for handling the security deposit. When you receive it, you're supposed to put it either in a separate escrow account or an interest-bearing account, and the lease should specify whether there's interest or not and who's entitled to the interest. But what do you do with the money after the tenant leaves? The deposit is normally returned to the tenant unless the landlord wants to make a claim on the deposit for damage to the property or some other reason. If you want to make a claim on the deposit, you have to give notice to the tenant, and you have to do it within a specific time frame. Otherwise, you might lose the right to make a claim on the deposit. In Florida, the statute has the language that has to be in the notice to the tenant, stating an intention to impose a claim on the security deposit, what the deposit is, what the amount of the claim is, the reason why. The deposit is $1,000, and I'm making a claim for $500 to repair damage to the walls, and the balance left, and what that would be sent to the tenant. Now, you give this notice to allow the tenant to either object to it, consent to it, or do nothing. If the tenant objects to it, then you have an issue. You can either negotiate it or end up back in court to determine entitlement to the deposit. But if the tenant consents to it or does nothing, then you can go ahead and dispose of the deposit in the manner as you described in the notice. But if you fail to give the notice to the tenant, you're going to waive your right to make a claim on the deposit.
Exactly. Remember that the landlord is required to give their notice by certified mail within 30 days of termination of the lease. The tenant then has 15 days to respond. If the landlord doesn't give the requisite notice within the 30 days, then the landlord loses the right to make a claim on the rent, on the security deposit rather. If the tenant doesn't respond within 15 days of receipt, then the tenant loses the right to contest the landlord's claim. And then the landlord can deduct the claim and return anything that's remaining.
So, to summarize the points that we've gone over, first, accuracy. The documents have to be correct, or you're going to have a problem in your eviction. That's the main thing to take from this. If you have any question whether there is a problem with your document, whether it complies with the statute or it has the right information or too much information, consult with your attorney. Get legal advice. Do it right the first time. Avoid potential headaches, liability, and exposure for the landlord.
Timing. Make sure that you're meeting all of your deadlines, make sure that you're not missing anything and waiving rights, because once the rights are waived, you can't get them back.
And speed. If you've done everything correctly and you comply with the deadlines, you'll be able to get the tenant out of the unit, regain possession quickly so that you can turn the unit into a productive investment, one that is generating rent, which is going to make everybody happy.
Thank you very much for your attention. We hope that we've presented this in an interesting and informative way, and we wish you well.
Take care.